The executive and legislative branches each hold a great deal of political power, but their authority is checked by the Supreme Court. Established by the Constitution, the Supreme Court is shouldered with the responsibility of interpreting the Constitution and ensuring that new laws conform to the Founders' original intent.
The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated time, receive for their services a compensation which shall not be diminished during their continuance in office. Article 3, Section 1 of the United States Constitution.
Supreme Court justices have earned one of the highest honors a U.S. citizen can attain, an achievement that does not come easily. The modern court is comprised of 8 associate justices and 1 chief justice, each nominated by the President and confirmed by the Senate. Appointment is for life. The Constitution imposes no limit on a judicial tenure, except to state that a justice has life tenure to serve the court during good behavior. When a vacancy does occur, a highly political and highly controversial process begins. Wanting a justice to share his ideology and political position, a president commonly looks to his own political party for a nominee. Often, the president will apply the litmus test to make a selection based on where a nominee stands on extremely divisive issues, such as women's reproductive rights or gay marriage. Senators who are responsible for confirming a nominee apply litmus tests as well. A nominee's previous statements and writings are reviewed to predict how the nominee might vote on particular issues.
I don't believe in litmus tests, but I believe very strongly that the right to choose and the right to privacy are fundamental constitutional rights, and I can't imagine supporting a Supreme Court nominee who doesn't share my view of the Constitution. I would use every effective means to stop a nominee I oppose. John Edwards, March 2004.
Supreme Court decisions are scrutinized publicly, a situation made even more difficult when justices are compelled to rule against their personal beliefs to uphold the Constitution. A recent example occurred in 1989. Ruling that Gregory Johnson had the right to burn the American flag, the Supreme Court was obligated to rule in Johnson's favor, based on the First Amendment. Despite their efforts to defend and protect the Constitution, Supreme Court justices can fall short of presidential expectations. Failing to reflect party beliefs in their rulings can be seen as a betrayal to those who appointed them.
Whenever you put a man on the Supreme Court, he ceases to be your friend. President Harry S. Truman.
Political ideology is not the only reason presidents typically look first to their own party for potential candidates. In 1952, Dwight Eisenhower used a federal judgeship to reward Earl Warren for campaign support. After being named Chief Justice of the Supreme Court, however, Warren's liberal actions repeatedly disappointed Eisenhower's moderate conservative administration. Several other factors are considered before Supreme Court appointments are made. Race, for example. Although there is no quota for the demographic makeup of the Supreme Court, there have been many references to the black seat, Jewish seat, and female seat over the years. The tendency of presidents to represent certain powerful minority groups on the Supreme Court was evident in 1991. When Thurgood Marshall, the first African-American justice, left the bench, he was replaced by another African-American, Clarence Thomas. Ronald Reagan's 1981 commitment to appoint a woman to the Supreme Court if elected president is another example. Sandra Day O'Connor reaped the benefit of that promise, and similar promises over the years have played a role in the highly controversial and highly political processes of both Supreme Court nominations and presidential elections. A presidential appointment is the necessary first step toward a seat on the Supreme Court, but the Senate must confirm all candidates. Each candidate's fate is determined at a confirmation hearing. By requiring appointees to provide personal and professional qualifications, senatorial confirmation protects against a president packing the court with friends and political partners. Senate hearings may even expose personal matters, financial dealings, and other aspects of the nominee's personal life. Clarence Thomas found this out all too well in 1991. After being nominated by President George H.W. Bush, Thomas faced extensive questioning from the Senate when former co-worker Anita Hill accused him of sexual harassment. The Senate, which had been preparing to vote on Thomas's nomination, called Hill in to testify and recalled Thomas to address the allegations.
I have been racking my brains and eating my insides out, trying to think of what I could have said or done to Anita Hill to lead her to allege that I was interested in her in more than a professional way.
Ultimately, the 2-week nationally televised hearing ended with Thomas being narrowly confirmed by a 52-48 vote and taking his seat as an Associate Justice. Another controversial nomination had taken place 4 years earlier. In 1987, President Reagan nominated Robert H. Bork, a staunch conservative, to fill a vacant seat. Perceived to be opposed to advancements in civil liberties, Bork saw his appointment defeated by a 58-42 margin.
Robert Bork's America is a land in which women would be forced into back-alley abortions. Blacks would sit at segregated lunch counters. Rogue police could break down citizens' doors in midnight raids. School children could not be taught about evolution. Writers and artists could be censored at the whim of the government. And the doors of the federal courts would be shut on the fingers of millions of citizens. Ted Kennedy, 1987.
Not all Supreme Court nominees are so eventful. David H. Souter, nominated by President George H.W. Bush in 1990, was dubbed the Stealth Justice. His clean record and qualifications as an attorney quietly won him confirmation by an overwhelming 90-9 majority. Though presidents control appointments and the Senate must confirm them, interest groups, people with shared beliefs and policy goals who have organized a well-funded unified voice on an issue, heavily influence both parties. Although they tend to have narrow concerns, the environment, education, and women's rights, for example, most interest groups are involved in a broad range of activities relating to their cause. Newsletters, websites, organized protests, financial contributions to parties and candidates, and press conferences all influence governmental nominations, appointments, and confirmations. One such interest group, the People for the American Way, PFAW, advocates the promotion of diversity. Founded by Norman Lear and now headed by President Ralph Nees, the PFAW puts the full force of its resources into lobbying political leaders to ensure that Supreme Court nominees represent America's diversity. The impact of the PFAW can be seen in the 2004 Supreme Court makeup: 4 liberal justices, 2 conservatives, and 4 moderates. Judicial diversity is a critical step in assuring the American public that each case that comes before the Supreme Court receives a thorough review. Despite being historically controversial and intensely political, the lengthy process for filling a vacant justice seat is necessary to properly protect and defend the United States Constitution, the foundation of American government.